the Kansas Emergency Management Act bills will come to order. So thank you for joining us, whether you're joining us here in the conference committee meeting room or on WebEx. So I'd like to welcome everyone, and this is the opportunity for your legislature, the House and the Senate, to come together at one table and work on solutions, finding solutions for Kansans. We've heard a lot from constituents, whether they be businesses or school parents or hospital workers, that Kansas needs to come up with an effective solution to balance, if you will, the government response to emergencies and personal rights and liberties, and make sure that we can do that in an appropriate, effective, prudent way. So it's my honor to be chairing the committee, and it's also my honor to have served on a committee in the House with the House delegation there, so and with Mr. Chair of Judiciary and Mr. Vice Chair and the ranking minority member in the House. And so then I guess I'm the only one who can say I've served with all the colleagues here on a committee. But looking forward to the work we have here to do. We are under a time deadline, I would say. The legislature in June of 2021 extended some provisions that were part of the response to COVID-19, and the governor signed those into law January 25th of this year, and some of those very important provisions and other areas of law are set to expire March 31st, 2021, unless the legislature takes some action. So that's what we are here to discuss today, and we are going to get to work and keep on task and move forward. But I would first like to give the opportunity for Mr. Chair of House Judiciary to say a few remarks if he would want to, or we can get right to work with the reviser.
I am anxious to get to work to find out what is in your bill, but thank you for having us at your conference committee meeting today. We're excited to jump in and figure out what's in these bills and see what compromise we can come up with. So with that, I'm ready to hear from the revisers and find out what we've got going.
Absolutely, yes. I think the House will find that the Senate bill is pretty comprehensive. It addresses everything from schools, local health officers, businesses, the Secretary of KDHE. And so with that, then, I will turn to Mr. Reviser, Mr. Jason Thompson.
Thank you, Madam Chair. This is Jason Thompson with the Reviser's Office. Good morning to everyone, and thanks for letting us appear via WebEx. It's very helpful. I'm going to share the chart that we have distributed to you.
Madam Chair, would it be possible for us to get a copy of that chart emailed to all of us so that we have it in front of us? It's very difficult to read when it's displayed like this. Thank you.
Yes.
Thank you, Mr. Reviser, and Representative Carmichael. I hear you have joined us on WebEx. Let's keep it running, just keep it running smoothly. If everyone could ask to be recognized before speaking, I think that would help move
Madam
things
Chair,
forward
I'd like
efficiently.
To be recognized.
Excuse me?
Madam Chair, I'd like to be recognized.
Yes, go ahead, Representative.
Would it be possible for the reviser to distribute the document to all of us via email so that we have an opportunity to see it clearly?
Thank you. Mr. Reviser, Mr. Thompson, are you able to email that to the representative and also put it on the website?
Thank you, Madam Chair. This is Jason Thompson with the Reviser's Office again. I did provide a PDF to both committee secretaries and our fellow research and reviser staff. I'll ask one of them to please provide that to Representative Carmichael, and while I'm presenting, and I assume he'll get that very shortly. I am unable to post it on the website, but by providing it to both of our secretaries, I hope one of them can do it. I think they have the access, but we do not. So, but we will work to get that out more publicly. We're attempting to at this time. So,
thank you, and I'll make that same request to the secretaries of the committee if that's who you're referring to, Mr. Thompson, let's please post that as soon as we can on the website. Thank you.
Yes. Thank you, Madam Chair. This is Jason again. And yes, I was referring to Iris and Kathy, the two committee secretaries. So
The committee assistants, perfect. Thank you.
All right.
Go ahead,
So,
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again with the revised statutes, and you have the chart now hopefully displayed on the screen or on WebEx if you're following along on WebEx. And paper copies are there in the room for those of you that are there. We tried to break this bill down by topic, more so than our usual comparison chart, so it might be a little different, but hopefully more helpful. We'll start with the types of disasters under KEMA, because for me, that's the biggest distinction between the two bills sort of out of the gate. You have current KSA 48-904 that just defines disaster broadly. It can involve any natural or man-made cause, including but not limited to fire, flood, earthquake, disease, etc. The Senate bill, substitute for Senate Bill 273, as amended by Senate Committee of the Whole, in Section 8, which is on page 14 if you wanted to go look, creates a distinction between a disaster under the current definition resulting from foodborne contagious or infectious disease and all of the other disasters already provided there, and distinguishes that from public health disaster, which is resulting from an infectious or contagious disease that is human to human transmissible, but not including foodborne illness. So we create two sort of distinct categories of disaster, and that's important because throughout the Senate bill, beginning even in new section 1 on page 1, there are different types of declarations, different types of actions that can be taken depending on whether it's a public health disaster or a regular disaster under KEMA. And as I mentioned, new section 1 allows the governor to issue a proclamation declaring a state of public health disaster emergency. The House bill does not distinguish between disasters. It is just the one definition under KSA 48-904, unchanged from current law. So that is a difference between the two. The second topic that we grouped the comparison under is the declaration, extension, and termination of a state of disaster emergency. In KSA 20, in the current KSA 48-924, of course, as amended by Senate Bill number 14 earlier this session. We have a subsection B5 in current law that relates to the COVID-19 emergency. You were only allowed to extend it past September 15th if the governor applied to the Finance Council for an extension of specified periods not to exceed 30 days each. While the legislature was not in session, those were, of course, exercised. And those extensions cannot continue past March 31st of this year. So that's the current law you're operating under. The Senate bill basically has no need for that anymore. The current disaster is dealt with sort of separately. The duties related to extension of an emergency that are conferred on the Finance Council under current law are given to a new Joint Committee on Emergency Management that's established by Section 2 of the bill. And we'll talk about that more later, that committee and its makeup. But the duties given to them are the same duties given to the Finance Council currently relating to extension of a disaster. And the last piece I'll mention here on the Senate bill is under new Section 1 for these new public health state of disaster emergencies. An initial declaration can continue for no longer than 15 days unless ratified by concurrent resolution of the legislature. When the legislature is not in session, the governor can apply to the Joint Committee on Emergency Management, and an affirmative vote of a majority of that committee may extend the disaster emergency for specified periods not to exceed 30 days each. So that would be the process going forward for these disasters. And I'll turn to Natalie Scott from our office to explain the House version of declaration, extension, and termination on the chart.
Thank you, Madam Chair. Under the House version of the bill, Section 4, KSA 48-924 is the statute that governs extensions still, particularly since we don't have a new specific public health type of disaster. So under the House provisions, an initial declaration may last up to 30 days. If the legislature is in session, then the governor shall make application to the Speaker and the President of the Senate to request extension of that disaster declaration. And the governor would also be required in that request to make application to use the powers granted in KSA 48-925. The legislature, if they're here, can take action to extend that disaster declaration through a concurrent resolution. That concurrent resolution would also have to state whether they're authorizing the use of powers in 48.925. If the legislature is not in session, then the governor would make application to the Legislative Coordinating Council for extension, and the council may extend that disaster for a time period as specified by the council. It would take an affirmative vote of 5 members of the council.
All right, and Madam Chair, Jason Thompson, again, taking back over after that explanation of the House version. The next topic on the chart is limitations on KEMA powers. We're in sections KSA 48-923 and 48-925 of KEMA. 48.923 currently just has some general provisions. It says nothing in KEMA shall interfere with certain labor disputes, dissemination of news, affect the armed forces, or limit the governor's authority to declare martial law. The Senate bill adds some things to that, and we'll talk about those in just a moment. Current law 48-925, of course, that we're all getting very familiar with, allows the governor to issue orders, and within 24 hours of the issuance of those orders, the State Finance Council meets to review those orders. We've been doing that process here for a little while now. The governor does not have the power under the current law to temporarily or permanently seize or authorize seizure of ammunition, or to suspend or limit the sale, dispensing, or transportation of firearms or ammunition. And the governor also does not have the power or authority to alter or modify any provisions of the election laws of the state. The final thing I would mention is counties are allowed to adopt orders relating to public health that are less stringent than statewide executive orders under your current law. So in the new Senate bill, new section 1, again, public health disaster emergencies, that section allows the governor to issue executive orders to exercise the powers conferred by that section, just like the governor is allowed to do under 48-925 current law. Under section 1, the attorney general will review each proposed executive order within 24 hours of receipt. At the same time that it goes to the attorney general, the proposed executive order goes to the Joint Committee on Emergency Management, and they also review the proposed executive order. They either review it not less than 24 hours after receipt, or at any time after the attorney general provides their opinion on the order, if that opinion comes in within 24 hours. So there's a small window if the opinion comes in, and then 24 hours if it takes that long for the attorney general opinion to come in. Counties may issue their orders relating to public health. That provision is moved from 48-925 to this new section 1 because it's only about public health. It fit better here. But there is a change. It no longer requires it to be a statewide order that they can opt out of. They may opt out of any order issued by the governor that affects more than one county. So anything more than one rather than statewide. In 48-923, I mentioned the Senate bill adds a few other items that the governor shall not have power or authority to temporarily or permanently do. The first is alter or modify the Kansas Criminal Code or the Code of Criminal Procedure. The second is take any action that imposes limitations on gatherings or other activities of a religious nature. The third is the sale or restriction of sale, purchase, transfer, etc. of firearms or ammunition. It is expanded a little bit in this definition from the current law version to cover a few more things about firearms and ammunition, most notably the manufacture components used in the manufacture of firearms or ammunition is the biggest highlight, I think. The fourth item added in the list here is election law. That's pulled in from the current law and essentially unchanged, as I recall. The fifth restriction is on any action that gives preferential treatment for elective abortion over any other elective medical procedure, or for an abortion provider over any other business or commercial activity. And then the final group of restrictions in number 6 is actually 4 restrictions that apply only during a state of public health disaster. So this is only under section 1, not under a 48-924 disaster declaration. And those 4 limitations are actions that substantially burden or inhibit the gathering or movement of individuals or operation of any religious, civic, business, or commercial activity, whether for profit or not for profit. Second, deem any business or commercial activity non-essential. Third, direct or permit any public official of the state or any municipality to mandate immunizations related to the disease named in the public health disaster emergency declaration. And finally, restricting the ability of a facility licensed under Chapter 65, essentially all medical facilities, to provide healthcare services. And it makes clear that any restrictions will be determined solely by the healthcare facility or the healthcare provider. The last thing I'll say on the Senate piece is that in 48.925, the governor may still issue executive orders under the Senate bill. The current power in subsection C1 is changed. You can look at how that's modified, but essentially the executive order can no longer suspend a statute. It can only suspend rules and regs and other orders, but it cannot suspend statutes. The powers conferred in C2 through C10 remain unchanged in the Senate bill. And then the power in subsection C11, where the House bill sends those powers sort of off in a different way, the Senate bill removes the C11 powers entirely. That is stricken from the bill. Other restrictions in current law, as I mentioned, are moved to 48.923 that I just talked about election law and firearms. And then the provision about county orders that are less stringent was modified and moved to section 1. So it's still in the bill, just in a different place. And I'll turn again to Natalie Scott from our office about the House position.
Thank you, Madam Chair. Natalie Scott in the Revisor's Office. Our provisions related to the limitations on powers under KEMA, new section 1 provides that executive orders that are not expressly authorized by KSA 48.925 C1 through 10 require application to the Legislative Coordinating Council. Once those proposed orders are submitted, the AG is required to review those proposed orders within 24 hours and provide an opinion both to the governor and to the Legislative Coordinating Council. The chair of the council would be required to call a meeting within 24 hours. And that proposed executive order may be approved by the Legislative Coordinating Council on an affirmative vote of 5 members. If the council does not approve the order, they can amend the proposed order and submit it back to the governor for possible issuance by the governor. They can request the governor bring a new proposed order, or they can deny the order and take no further action on that order. New section 2 starts on page 3. The Legislative Coordinating Council would be required to meet to extend disaster declarations as authorized by KSA 48.924, and they would also meet to authorize the use of powers conferred by 48.925C when the legislature is not in session. Section 3 amends KSA 46.1202. That's a statute related to the Legislative Coordinating Council, just to provide that the council is authorized to carry out the duties that are prescribed by KEMA. And then in section 5, 48.925, that's starts on page 7 of our bill. After that initial 30-day disaster, the governor would have to make application to the legislature if you guys are in session, or the Legislative Coordinating Council if you're not in session, to obtain authorization to use those powers in KSA 48.925. And any order that would be issued would have to be sent to the Attorney General, who would be required to review it and provide an opinion as to the legality. Our version, the House version of the bill, does retain the restrictions on not making changes to election law. It retains the firearm restrictions, but it just keeps it in 48.925. The House version of the bill doesn't make any changes to 48.923.
Thank you, Natalie, and thank you, Madam Chair. This is Jason Thompson again. The last sort of big piece here on this page is the legislative oversight. We grouped these here. Obviously, there's different pieces that you might need legislative oversight in each bill, so it's a little all over the place, but hopefully having it here will give you an idea of who does that oversight and in what manner. You, of course, realize that under 48.924 in the current law, that emergencies may only last 15 days unless ratified by concurrent resolution of the legislature. And the legislature, of course, has the power at any time to require the governor to terminate a state of disaster emergency. And then in 48.925, we have that executive orders issued by the governor may be revoked at any time by concurrent resolution of the legislature. So under new section 2 of the Senate bill, the Joint Committee on Emergency Management that is created has a lot of these oversight functions as well, including reviewing executive orders, standing in for this in place of the State Finance Council for the powers they have under current law. So I'll just highlight briefly here that it is a 12-member joint committee, 6 Senate members, 6 House members. The members shall represent each State Board of Education member district under KSA 4-526. To meet the requirements of that representation, essentially each appointing authority has to sort of confer with each other to make sure that their individual appointments all add up, to make sure that all 10 of those State Board of Education districts are represented amongst the 12 members. That's how that committee is set up. And they have a few additional powers outside of KEMA, the ability to be an investigative committee where they can call in folks and subpoena folks to carry out their duties. They can also receive reports from various public officials that might have information relevant to emergency management. So it's focused quite a bit on the emergency and the powers under the emergency, but it has a few powers that go beyond that are related to those powers and duties. We also note in the Senate bill, and we'll get into this more later, but highlighted here, 65-101, which appears on page 23 of the bill. The legislature may require the Secretary of Health and Environment to terminate an order issued under subsection A5 of that statute at any time. So that is not in current law, but would be an additional legislative oversight power given in the Senate bill. And I'll turn again to Natalie for the House legislative oversight provisions.
Thank you, Madam Chair. Natalie in the Revisor's Office. The legislative oversight portions of the House bill are contained in a few different sections. New section 1, as I mentioned earlier, executive orders issued under that section would have to be authorized by the Legislative Coordinating Council by an affirmative vote of 5 members. Under new section 2, the Legislative Coordinating Council would meet to extend the disaster declaration and to authorize the use of powers under KSA 48925 when the legislature is not in session. Section 4, KSA 48924, when the legislature is in session, then the legislature would be responsible for extensions of the disaster declaration and for authorizing the use of powers in KSA 48925. And then in section 5, KSA 48925, after that initial 30-day disaster, the governor would have to make application to the legislature, if you're in session, to the Legislative Coordinating Council if you're not in session, to obtain the authorization to use the powers in KSA 48925. The House version of the bill does retain the current law provisions that a concurrent resolution of the legislature can require the termination of a disaster declaration at any time. And it also retains the current law provisions that the legislature can terminate an executive order by a concurrent resolution at any time.
All right. Thank you, Natalie. Thank you, Madam Chair. Jason Thompson again with the Revisor's Office. And I should note, as Natalie did, that the Senate bill does preserve those same provisions that I mentioned in the current law column. I sort of glossed over that, but that is in both bills. That's an excellent point. The next couple of provisions here under KEMA, we'll go a little quicker, and then Madam Chair, I may pause after that to see if there's anything before we move into some provisions that are in the Senate bill that may not be as much in the House bill that aren't directly related to KEMA. So be prepared for that potentially. So the couple here on this page that I'll highlight are the category of compensation under KEMA. Of course, KSA 48-933 in the current law allows for compensation of the use, damage, loss, or destruction of property that occurs under the Act. The amendment in the Senate bill, which you can find on page 21 and thereafter, would add a reference to our new declared state of public health disaster emergency under Section 1. It also would add that nothing in this section authorizes compensation for intangible losses. There's been some debate about whether those are allowed or not, and this would make explicit that it is not allowed under KEMA. You would have to seek another means of recovery for those losses. The House bill has no provision. It is just the current law provision under 933. No changes to that law in the bill. The penalties for violations of KEMA or orders issued under KEMA is the next category. KSA 48-939 is the provision in current law that you changed in the 2020 special session bill to provide that if you intentionally violate the act or orders issued under the act, you can receive a civil penalty not to exceed $2,500. Those actions are enforced under Chapter 60 by either the Attorney General or the local prosecutor, the county or district attorney, and they can also seek injunctions. The Senate bill changes those penalties so that intentional violations during a state of disaster emergency under 48.924, so the fire, flood, tornado sort of disasters, or under state of local disaster emergency under current law. Those would go back to what they were before the changes in the special session to a Class A non-person misdemeanor. So those would be criminal offenses again, and that was done at the request of law enforcement in the Senate committee. That amendment was adopted after that was requested. The intentional violations during a public health disaster emergency under Section 1 would remain a civil penalty only, just like under current law. A $2,500 fine enforced through an action under Chapter 60. So it creates two different penalties depending on the type of disaster. One is civil and then one is criminal. The penalties for violations in the House bill do not change. They remain as they are in current law, civil only. The only other change that's even in the same chapter as KEMA is the final one here on this that I'll highlight here, definition of emergency responder. That's KSA 48-949. That's actually part of the Kansas Intrastate Emergency Mutual Aid Act, and it defines emergency responder. The definition is expanded to include 911 dispatch center personnel. That was a request made to committee. It was adopted as an amendment, and you'll see that the same amendment appears in the House bill. It's on page 23 in the Senate bill and page 11 in the House bill. And Madam Chair, if it's appropriate, I'd be willing to stop for questions on the KEMA provisions before we move into federal funds and some other provisions if you'd like.
Thank you, Mr. Thompson. Yes, I think that would be appropriate at this time. I'm going to start with a few questions of my own. Back to page 1 of the comparison, I'm seeing that the Senate bill has created a new category of emergencies, that public health disaster, is that right?
Madam Chair, this is Jason Thompson. Yes, that's correct. New Section 1 is about public health disaster emergencies.
Thank you. And the Senate bill then goes on to define public health disaster on page 2, that I think it's page 2. No, I think it's later on. I apologize. To define that it's not a foodborne illness and it's a different category of disaster to address contagious diseases and things like that. And that's not covered in the House bill, is that correct?
Madam Chair, this is Jason Thompson with the revisor again. Yes, my understanding is that the House bill does not amend the definition of disaster. It does not create a separate category of disaster emergency declarations. It is all under the same 48-924 framework that we have now. If Natalie has anything to clarify, I'd be happy to let her do that.
Natalie, did you have anything you wanted to clarify?
No, Madam Chair, that's accurate. The provisions in the House bill don't make any differentiation on the type of disaster, just the one type of disaster. We do keep the current law provisions related to drought disasters, but otherwise all disasters would be the same. And I would even maybe note that the current law in KSA 48-924 does have a different type of disaster for certain agricultural issues, and the House version strikes the special provisions related to those certain disasters.
Thank you. And there was a difference in, there was a new joint committee on emergency management created in the Senate bill that's not in the House bill. Is that accurate?
Madam Chair, that is accurate. The House version of the bill assigns any duties that are not to be handled by the legislature when you are in session to the Legislative Coordinating Council.
Thank you. And the Joint Committee on Emergency Management established in the Senate bill, that specifically requires the members to be comprised of one legislator from each of the 10 Kansas State Board of Education districts. Is that right?
Madam Chair, Jason Thompson with the revisor again. Yes, that's correct. In new section 2, if you look in the bill, beginning on about page 6, the description of the 12-member Senate committee, as amended by the Senate Committee of the Whole, is now required to represent the 10 member districts of the State Board of Education. And so the substitute bill, as it left committee, had 12 members appointed by leadership in the Senate and leadership in the House. The 12 members coming out of the Senate Committee of the Whole still has those members appointed by leadership, 2 by the president, 2 by the minority leader, 1 by the chairperson or vice chairperson of the Joint Committee on Information Technology. And then on the House side, 3 representatives by the Speaker, 2 by the minority leader, and 1 by the Joint Committee on the chairperson or the vice chairperson of the Joint Committee on Information and Technology. So some leadership make the appointment, but also a Joint Committee on Information Technology chairperson or vice chairperson makes 1 appointment. They can appoint themselves, but they all have to consult with each other. And ultimately, each State Board of Education member district, which is, there are 10 of them, have to be represented by the 12 members.
Thank you. And I think the intent there was to make the body that makes the decisions on while we're not in session or while we're in session is more representative of the citizens across the state of Kansas, which has been not necessarily the case currently that we're operating under. And then the Senate bill adds in, I'm sorry, I'm jumping around. It continues the restriction, I guess, in section 1 that counties may issue an order relating to public health that includes provisions that are less stringent than the provisions of an executive order. Does the House bill do the same thing?
Madam Chair, Natalie with the revisor's office. Yes, the House bill can keeps current law
Okay, good.
provisions in KSA 48925H. We did make 1 minor change to that so that it would be orders that are related to the public health of humans and that are not related to the food supply chain.
Okay, so a little bit different because the House doesn't have the new category of public health disaster.
Madam Chair, if I could.
Yes.
This is Jason Thompson with the riser again. I also just wanted to highlight the 1 change from current law, not only moving it to section 1 where it's public health only, which it is under current law as well, but it also broadens the provision so that counties may issue less stringent orders if the executive order affects more than 1 county. The current law and the House version still requires that it's a statewide order. So there's a difference there that I would highlight as well.
So it further restricts, or I guess it allows counties to opt out of more executive orders. Is that right?
Thank you, Madam Chair. Jason Thompson again. Yes, so the Senate version, if any executive order applied to 2 or anything more than 1 county under the Senate version, a Board of County Commissioners could enact a less stringent order, but under the current law and under the House provision, it only applies if the executive order is statewide. So
Okay.
there would be an opportunity for more orders by the county under the Senate bill. Yes.
Okay, thank you. And the Senate bill also includes on page 15, section 9, when it's talking about the governor shall not have the power or authority to temporarily or permanently do certain things. The Senate position, the Senate bill added in manufacture of firearms or ammunition, and that was because that wasn't previously in current law. Is that right?
Thank you, Madam Chair. Jason Thompson again with the revisor. Yes, so if you compare the language of current law, it is seize or authorize seizure of any ammunition or suspend or limit the sale, dispensing, or transportation of firearms or ammunition. And those are preserved in the House bill in the same place they are now, 48.925. In the Senate bill, they're moved to 48.923, and it is a little broader. Limit or otherwise restrict the sale, purchase, transfer, ownership, storage, carrying, or transporting of firearms or ammunition, or any component or combination thereof, including those used in the manufacture of firearms or ammunition, or seize or authorize seizure of any firearm or ammunition, or any component or combination thereof, except as otherwise permitted by state or federal law. So there's a few more things in there for sure, specifying carrying or transportation, for example, components or combination of firearms or ammunition, maybe making that a little clearer, and then components components that are used in the manufacture of firearms are more clearly covered by this than under current law.
Thank you. And I have other questions, but I want to open it up to the committee for some questions as well, the revisor at this point.
Madam Chair, I am going to have questions, but I will get with Nate, Jason, and Natalie since the House only has 20 more minutes, and I'd prefer they spend their time giving us the overview, and then I'll get with them on the questions.
Okay, I think it's important that we do get through the overview, and we'll see how long it takes. But
Got it.
okay, thank you. So with that, yes, Senator Corson.
Thank you, Madam Chair. One question, Mr. Thompson. I just want to make sure, because we talked about this in committee, we talked about it a little bit on the floor, and I just want to make sure that I understand how the revisor's office is interpreting this. So this is on page 4. It says the chairperson, I'm on line 20, on 2021, on page 4, it says, the chairperson of the joint committee shall call a meeting of the joint committee for the purposes of reviewing such order. And then before that, in line 20, it says, basically, it says not less than 24 hours after receipt that this meeting has to be called, if you read lines 18 through 22. So my question is the revisor's office, do you interpret that as called means the meeting has to be held within 24 hours, or just that it has to be called, meaning scheduled, and that the actual meeting could be a week later, 10 days later, 14 days later, kind of at the discretion of the chair? And I just want to make sure I understand how the revisor's office understands that language. Thank you.
Thank you. Mr. Thompson, if you can.
Thank you, Madam Chair. Jason Thompson with the revisor again. I'm not sure that we have an official position, so I don't want to go on that branch completely. But I will note that it does say in line 21, it says shall call a meeting. And I think there is a little room for interpretation there about whether that means it should be held or just called. And honestly, that would fall on the chairperson of the committee and their interpretation, because the committee meets on call of that chair, just like other committees do. There was discussion in the Senate committee about whether to add and hold to make clear that it's call and hold. That is, of course, an option. And I don't recall in the House bill if there's language about calling and holding. So maybe if Natalie could chime in with what they did in the House bill to make clear that the meeting would be held within a certain amount of time. I believe there's something like that in the House bill.
Thank you, Madam Chair. Thanks, Jason. Yes, the House version of the bill, when we reference the meetings to be held by the Legislative Coordinating Council, the language that is used is the chairperson of the Legislative Coordinating Council shall call a meeting of the Legislative Coordinating Council to occur within 24 hours of receipt of such application. There's an example of that at page 3, starting at line 13. So that's the language from the House bill.
Thank you. Other questions, committee, or should we proceed through the comparison chart? All right, seeing none, we'll go ahead and proceed then. Thank you.
All right, thank you, Madam Chair. Jason Thompson again. Continuing on page 5 of the chart, the federal funds category. We, of course, have current appropriations provisions dealing with federal funds and expenditure thereof, and even current state finance council procedures for emergencies and how those funds can be expended. I just highlight new section 7 on page 13 of the Senate bill, makes an explicit provision that expenditures may not be made against any federal grant or other federal receipt without previous appropriation or reappropriation by the legislature until the Joint Committee on Emergency Management has authorized the agency to make the expenditures. So the process that was used for the current expenditure of federal funds under your special session bill, where that went through the Finance Council, there may still be some Finance Council role in expenditure of funds, but this is specific to emergency funds or funds that are received in relation to a declared state of disaster emergency. Those would only be expended by the agency after approval by the new Joint Committee on Emergency Management. So that's a provision in the Senate bill, but no such provision in the House bill. The House bill would rely on the current law and the current appropriations provisions. We then move into another big category that's covered in the Senate bill and not in the House bill. This deals with Secretary of Health and Environment and orders issued by the Secretary. I just highlight subsection A5 of the current powers and duties. Authorizes the Secretary to issue orders to take action to prevent the introduction of infectious or contagious disease and to prevent the spread of infectious or contagious disease. So the Senate amendments are specific to that subsection and this type of order, not the others provided in that section. If it affects more than one county, again, similar to the change we referenced earlier about executive orders. So if it affects more than one county, the Secretary is required to submit that proposed order to the Attorney General for review, just as done in Section 1 for a proposed executive order, and also submit that order to the Joint Committee on Emergency Management, just as required under Section 1. So the Secretary of Health and Environment would have to have these orders reviewed just like an executive order is the end goal here. The Secretary shall not issue an order that substantially burdens or inhibits the gathering and movement of individuals or operation of any religious, civic, business, or commercial activity, unless there's the justification of accepted scientific reasons and how it's narrowly tailored to accomplish remediation of the disease. They can also not burden or inhibit the operation of any religious gathering or activity through their orders. If a person is aggrieved by an order, they may request a hearing to occur within 72 hours. And then they may request a hearing in a district court if they're aggrieved by that decision as well. At any time, the legislature by concurrent resolution may require the Secretary to terminate one of these orders. So that I highlighted that earlier and I highlighted it again here. And as I mentioned, there's no provision about the Secretary of Health and Environment in the House bill. It would remain as it is under current law. The next big grouping relates to those Secretary of Health and Environment powers, but at the local level. So we have health officer orders under current law. I highlight 65-119, 65-126, 65-201, and 65-202. And I'll basically just speak to the changes, so keep this short. So the biggest change in the Senate bill is that health officers may only make recommendations. They don't make orders under the Senate bill. Only governing bodies may issue orders. So new section 3 deals with the governing body of a city. They're only allowed to use accepted scientific means to justify their orders to prevent the spread of disease. They're not allowed to substantially burden or to burden or inhibit religious gathering. The same two restrictions I just mentioned earlier. They're not allowed to issue orders that do the same things we just talked about before. And again, if you're aggrieved by an order, you may request a hearing with that governing body within 72 hours. And if you're aggrieved by their decision after that hearing, you may request a hearing in the district court. And I talk a little bit more about that judicial review later, but I'm just putting it in here that is an option, and we'll discuss it more fully in a moment. Under 65-119, the Senate bill prevents a board of health or local health officer from any school district issuing an order doing anything that would prohibit any school district, attendance center, non-public school, community college, or technical college from operating. So essentially, those are all left to those bodies and not a board of health or local health officer. And then 65-126, the section that allows certain powers and duties would not apply to a school district, attendance center. Again, all the same things I just mentioned during a state of public health disaster emergency. So during those disasters, those bodies have power over those entities rather than health officers. And then I highlight 201 and 202. Recommendations issued by the local health officer are reviewed by the Board of County Commissioners. The board may then issue an order. So these are your local health orders right now. Will only be issued by the board and not by the officer. They have the same restrictions about not substantially burdening certain activity and not burdening or inhibiting religious gatherings or activities. And there's a third one added for these restrictions. They cannot issue an order that has the effect of limiting travel between counties. I think there's one exception to that, but essentially they're not allowed to prohibit someone from another county from coming in to their county. Again, it has the review within 72 hours by the governing body, and they can request a hearing in district court. And finally, 65202, local health officer recommendations and guidance are subject to all those same limitations that we just talked about in 201. So even their recommendations can't propose to substantially burden or violate these provisions in 201. And as I mentioned, none of these are in the House bill. This is exclusive to the Senate bill. Then I briefly can highlight the schools provision. I mentioned that the health officers are prohibited from doing certain orders related to schools. You are, of course, remember under 48-925B of the current law, the governor is not allowed to issue an order that closes public or private schools unless that order is affirmed by the State Board of Education by a majority vote. That section is repealed by the Senate bill, and in its place essentially is the restriction on all of these orders and a provision that says in new section 5 that a Board of Education of a school district during a state of public health disaster emergency is the only entity that has the authority to take any action or issue any order that affects the operation of any school within the school district. And then there's also provisions for anyone aggrieved by those orders issued by the school district can request a hearing by the board within 72 hours to occur within 72 hours, and then they can request a hearing in the district court as well. I would turn over to Natalie, but I think I can summarize this one quickly enough that under 48-925B, the amendment in the Senate or the House bill, rather than repealing that provision, the House bill just says orders issued under this section shall not impact private schools, and they can only affect the operations of schools under the jurisdiction of the State Board of Education. The law probably already says that, but to clarify that it does not apply to private schools, it's made explicit. And that would be the same in the Senate version of new section 5. That only applies to the Board of Education and the schools under their jurisdiction. Private schools don't have their own provision because they're subject to their own restrictions or their own governing body already. So we only have one for the public schools provided in the bill. A similar provision in new section 6 of the Senate bill for community colleges and technical colleges. I won't go into any detail there. I just highlighted there in the chart. They have the same oversight of their body or of their colleges as the school boards do of their schools. And then the last big thing here is judicial review. I note current law 65-129C is where we draw that 72-hour hearing provision from. If a local health officer, the Secretary of Health and Environment orders isolation or quarantine under current law, you have the right to a 72-hour hearing if you believe you're unlawfully subject to one of those orders. And that provision sort of carries forward into many of the things we just talked about briefly. The new section 4 of the bill in the Senate provides that procedure for a hearing in a district court when you've been aggrieved by a decision of either a city, a board of county commissioners, the Secretary of Health, or one of those bodies of a board of education or a technical or community college. I'll mention that it can be brought under Chapter 60, and the district court has to schedule it, has to schedule and give notice of the scheduling of the hearing to the aggrieved party within 72 hours after receipt, and then the hearing has to occur within 10 days after receipt of the request for the hearing. And that is not allowed to be extended for any reason. So 72 hours to get it scheduled. Within 10 days, it has to occur. No extensions allowed, but the Chief Justice can, of course, issue orders to authorize remote appearances and two-way audiovisual appearances. I think that summarizes it for me. If Natalie wants to speak to the House provisions on judicial review really quickly, I know we're running out of time, and I think we're almost done. This is actually the last piece other than severability. So I'll turn it over to Natalie to summarize judicial review, and then I think we're done.
Thank you, Madam Chair. Natalie with the Revisor's Office. The judicial review provisions in the House bill mostly relate to judicial review of executive orders. So under new section 1, a party aggrieved by an order issued under that section can petition for relief in the district court, either where they live or in Shawnee County. The court has to hold a hearing within 75 hours, and they would be required to grant relief unless the court finds that order is narrowly tailored to respond to the state of disaster emergency and uses the least restrictive means to achieve that purpose. So essentially, that's going to be a strict scrutiny standard if that is one of those new section 1 orders. Under section 5, KSA 48.925, these provisions start on page 7 in the House bill. A party aggrieved by one of those orders can petition for relief again in the district court, either where they live or in Shawnee County. The court again has to hold that hearing within 72 hours, and they would be required to grant relief unless the court finds the order is necessary to achieve an important interest related to the state of disaster emergency and is substantially related to that interest. That's more of an intermediate scrutiny standard, except that if the order that is being talked about substantially burdens religion or business, then the court would be required to grant relief unless the order is narrowly tailored to respond to the disaster and uses the least restrictive means to achieve that purpose. So if it's related to religion or business, then it gets strict scrutiny, and all the other 48.925C orders get intermediate scrutiny.
Thank you, Ms. Scott. Appreciate the revisor's work in putting together the comparison chart and the review of it today. Committee, do we have questions for the revisers? Yes, Senator Corson.
Can you talk on the bottom of page 5, you say federal funds, when you say current appropriations provisions and then current law on the House side, just if you know them, what are those? What is that? Can you just explain what you mean a little bit by current appropriation provisions? Is that just the normal legislative appropriations process, or can you explain that a little bit?
Does either Mr. Thompson or Ms. Scott want to answer that, please?
Thank you, Madam Chair. This is Jason Thompson with the revisor again. I'm not an appropriations revisor, and I don't play one on WebEx, but I'll attempt to answer the question. You recall that in the special session bill, you did have 4 sections at the beginning of that bill that restricted the use of federal funds from the Coronavirus Relief Act and other federal sources, and gave authority to the State Finance Council to approve all of those expenditures. The Finance Council did exercise that authority. My understanding is that they passed a resolution that essentially said all the federal funds may be expended. And so they did their job and allowed those to be expended. But of course, those only applied for fiscal years 21 and then fiscal year 20. So those are going to expire at the end of this fiscal year anyway. You, of course, could have any provisions in your appropriations bill that deal with federal funds. So those would all be part of the law restricting the expenditures. There are even a couple provisions in the Finance Council statutes that I didn't get into in the brief, but I've been made aware of by our appropriations revisors that allow expenditures of, I think it's up to $10 million for during certain emergencies. So that would come into play potentially. But essentially, the House version of the bill would just be monies that come in related to federal funds. If there's an appropriations provision, it would govern. If there's a Finance Council provision that's applicable, it would operate. But the Senate version would have a very specific statute that says these federal funds have to go through the joint committee that's created in order to be expended by any state agency. So it would sort of trump many of those other things.
Thank you. And again, that joint committee in the Senate bill is a broad representation of all those in Kansas, all Kansas citizens, because it has at least one legislator from each of the 10 state school board districts. Is that right? As best as we can to get all 10 districts represented on the joint committee on emergency management, right?
Thank you, Madam Chair. Jason Thompson again. Yes, under the provision as it left the Senate Committee of the Whole, the statute is explicit that the appointing authorities must cooperate to ensure that all 10 of those state board districts are represented by the 12 members. And they can appoint themselves or they can appoint another legislator, but their job is to collaborate and coordinate to ensure that all 10 of those state board districts are represented.
Thank you. Committee, other questions? All right, I don't see any. I know that the House members have some obligations, so I don't want to go too long over into that. We do have, I think has been brought to our attention that there are certainly some gaps between the Senate and the House bills that I think we'll need to discuss. For instance, the penalties that law enforcement had brought and that the Senate bill contains, and we just heard about the expenditure appropriation of federal funds like CARES money and things like that that might come in. Schools are specifically addressed in the Senate bill. Community colleges are specifically addressed. The local health officers can issue recommendations but not orders under the Senate bill. So lots of things to work with, and that when you have a governing body, a local governing body, whether it be the city, the county board of commissioners, or the school district, you have a right to a hearing if you're an aggrieved person by the policy or the action or the order. That's in place in the Senate bill. So a lot to discuss. And I think given that we've got that March 31st, 2021 deadline looming, we're going to meet, I'm going to call a meeting that we will meet tomorrow at 10 a.m., same room. And I think we should start with, if we have further questions about the differences in positions, and start taking a look at that. By that time, I believe that we'll be in a good position to take a look at it and start working on the deeper dive again. We do have that deadline approaching, and to get something in place that, I don't know, I think all of us on the committee and our colleagues have been hearing from Kansans that they want something put in place, and that it's our job as the legislature to work on that and get that done. So with that then, committee, a comment or question from Senator Wilborn.
Thank you, Madam Chair. I appreciate the revisers for the hard work and the parallel comparison between the two. And my remarks are very similar to the chairman's, not to repeat, but there's quite a few areas that are different or missing. And I think it's very important that both sides focus on that in the absence of meeting officially, so that we can get right to the point when we get back. So, thank you.
Thank you, Senator. That's a good point, well taken, appreciate that. And without then any further comment or questions, committee, we are adjourned. Thank you.